Good evening, everyone. I'd like to commence by acknowledging that I work on the land of the Wurundjeri people of the Kulin Nation, and I would like to pay my respects to their elders past and present, and to their emerging leaders also. A very warm welcome to you all. I'm Pip Nicholson, the Dean of the Melbourne Law School, and it's an absolute pleasure to welcome you to the 2021 Alan Hope Southey Memorial Lecture. Before I formally introduce our chair and the guest speaker, together with the series itself, I'd like to address a few brief housekeeping matters. The first of those is that the chat function has been disabled, but we very much welcome your questions, but I ask you to put them through the Q&A function if you wouldn't mind. I also want to note that the presentation tonight is being recorded and will be available publicly shortly after the lecture. Can I commence with a few preliminary comments about the Alan Hope Southey Memorial Lecture series. This lecture was established in 1958 by Ethelthorpe Southey, better known as Nancy Southey. And the ambition was to endow a law lectureship in memory of her husband, Alan Hope Southey, who graduated as a Master of Laws at the university in 1917. Now, over 60 years later, the Southey family continue to support the lecture series at Melbourne Law School, and I would like to take this opportunity to thank them for their ongoing generous support. I would also like to extend a very warm welcome to the Southey family and say how much I regret not being able to welcome you in person. But heartfelt thanks for the support for the lecture series, which we hold in honour of Alan Hope Southey. Can I now move to make a few preliminary remarks by way of introduction of the chair of the Q&A session following the lecture. The chair tonight is Professor Jackie Peel from Melbourne Law School, who's been instrumental in organising Chief Justice Preston's engagement with us this evening. Jackie is herself an expert in the field of environmental and climate change law. Jackie is also the director of Melbourne Climate Futures, which is a research initiative of the University of Melbourne. MCF, as we've come to know Melbourne Climate Futures, pulls together research in the area of climate and climate change from across the university. And in particular, it picks up issues from climate change impacts in the Pacific to environmental politics in the global stage, energy futures, bushfire resilience, better global health outcomes. So it's a very broad suite of research undertaken and led by MCF, and we're delighted to have this lecture connected with the work of that initiative. But now it's an extraordinary pleasure to introduce our guest speaker for the evening, Chief Justice Brian Preston, Chief Judge of the Land and Environment Court of New South Wales. Prior to being appointed to the court in 2005, Justice Preston was a senior counsel practicing primarily in New South Wales in environmental planning, administrative and property law. He's also the author of Australia's first book on environmental litigation and has authored an extensive catalogue of publications on environmental litigation, administrative and criminal law. Chief Justice Preston is also a member of various international environmental law committees and advisory boards, including the Interim Governing Council of the Global Judicial Institute on the Environment and chair of the Environmental Law Committee of the Law Association for Asia and the Pacific. In 2019, Justice Preston was a visiting fellow at Corpus Christi College, University of Oxford, and last year was the Robert S. Campbell Jr. visiting fellow at Magdalen College, University of Oxford. He is currently an adjunct professor at the University of Sydney, Western Sydney University and Southern Cross University. Chief Judge, we are deeply honoured to host you this evening for the 2021 Alan Hope Southey Memorial Lecture, and I'm delighted now to welcome you to the platform.
So thank you very much. It's a great honour. I did really wish to come to Melbourne to be able to give the lecture in person and see you all, but unfortunately, of course, lockdowns in both New South Wales and Victoria have prevented that. So we'll do it virtually. The topic, as you can see from the slide I popped up, is climate conscious lawyering. I wanted to pick a topic, obviously about law, but a law for the current moment. And just recently, in the last week, there was a report issued from the Intergovernmental Panel on Climate Change. It's their 6th assessment report, and the particular report that's come out is the Working Group 1. And it, again, gives the warning about climate change and its problems. One of the conclusions was that it's unequivocal that human influence has warmed the atmosphere, the ocean, the land, and that widespread and rapid changes in all of these Earth systems have occurred. And the scale of the changes across the climate system and its subsystems are unprecedented over many centuries, indeed to many thousands of years. So the UN Secretary General described this recent report as a code red for humanity, emphasising the importance of doing something about it. So let's see how that impacts upon legal practice, and that's what my particular lectures are going to be about. Now, it may be that lawyers have thought that environmental law, but particularly the subset perhaps of climate change law, is for others, that it doesn't intersect with daily legal practice. But in fact, that is increasingly being shown to be short-sighted. As Professor Margaret Young in a forthcoming article has said, we are all climate lawyers now, whether we are practicing in that area or not. There is this intersection of the issues of climate change with our daily legal practice. But we can also see, and I'm not going to spend too much time on this, but there also is an impact of legal practice on climate change. And that is that when we think about lawyers and the law firms in which they act, but they can be seen to be climate change actors themselves. They're not necessarily non-aligned or apolitical. I'll come later when I'm dealing with education to see how law students have been ranking some of these law firms, because it's being seen that increasingly the law firms are having an impact on climate change by who they act for, what advice they're giving, and what arguments they're putting. And so these will be points I'll come back to. But let's turn to the main way I want to talk in this lecture, and that is the impact of climate change on our lawyering. And I'm using the expressions a climate conscious approach, and I distinguish that from a climate blind approach. So what do I mean when I talk about a climate conscious approach? Well, what it involves is an active awareness about climate change and how it interacts with the daily legal problems. So it's not talking about sort of taking necessarily a substantive outcome. That is, you have to be sort of pro-climate change and not a denier of climate change. What I'm talking about is we're recognizing that climate change does exist and looking in an active way to find out how it interacts with the day-to-day legal practice. And I contrast that with the climate blind approach. And so where the outcome of a particular legal problem that we're looking at or the dispute will have an impact on climate change issues, but nevertheless the legal advice is given or the dispute is litigated and resolved without any attention being given to those climate change issues. So I want to next talk about how we, I say reasons here, but it's really sort of ways in which we can be climate conscious lawyers in what is done in daily legal practice. And I've divided it into 5 topics. The first two deal with the law, and the next three deal with ethics. In the first two, I'm looking at the law, and in the first one, I'm saying that when we think about what is the law, that is not the only matter we should give a legal advice about. We are lawyers, of course, but we need to give advice about all different aspects of the dispute, of which law is the only one. I'll come and explain that further. The second one is saying that, well, even if we are just going to look at the law, the problem is that what is the law and what's not the law is really uncertain. And I'll identify why that's so and what that means. Then the third, fourth, and fifth are dealing with our ethical obligations as lawyers. I start with the most general, as the legal professional ethical obligations. I second come down to the more particular ones about our ethical obligations to the court and to the legal system. And the fifth one is even more particular, dealing with our personal ethical thinking. So let's start with the first one. Now, when we think of when a client walks in and says, this is my problem, they never actually identify it as a legal problem. They think it might be a legal problem because they've come to a lawyer. But really, the issues involved in that particular problem or dispute are only partly about the law. There'll be many different aspects. So, of course, the lawyer's expertise is on the law, and they will need to advise on the legal issues. But they may also need to counsel the client about other issues. And that's because in order to solve the legal problem, you've also got to solve other aspects, the financial, the emotional, psychological, the relational or social, the environmental or ethical consequences of different courses of action. And so by providing that holistic advice to the clients, they can better understand all of the consequences and the costs and the uncertainties associated with alternative courses of action, about what to do about the problem, and they can make an informed choice. Now, this idea that we need to provide holistic advice has been recognized by the peak legal associations. I give one example there about LawAsia, the Law Association for Asia and the Pacific. They've issued a sort of toolkit about the intersections of business, human rights, and the environment. And they're recognizing that lawyers need to provide advice about all of these issues, not just only about the legal aspects. Or another peak body, the American Bar Association, they adopted a resolution in 2019 that lawyers should advise their clients of the risks and opportunities that climate change provides. Right? So not just about the law, but all of the risks and opportunities. Or another body, the International Bar Association, in May 2020, they ratified a climate crisis statement. I'll come refer to this a few times, but at this point, I just pick up 2 points. One, urging lawyers to take a climate conscious approach to the problems encountered in daily legal practice. And secondly, advising that lawyers should advise the clients of the potential risks, liability, and reputational damage that arises from activity that negatively contributes to the climate crisis. So let's just pick up on that last point, that is about providing advice about the climate-related risks. And so if you're going to give a holistic legal advice, it won't only be about, for example, what I put there, the third item, that is the liability risks, the risks of the business being held liable for, contributing to, or failing to adapt to climate change. That clearly is a legal question. But look at the first two, the physical risks and the transition risks. So physical risks are the risks that physically impact the businesses, for example, the extreme weather events. So if a client has assets by the coast or is thinking of carrying out development on the coast, and that coast may be impacted by climate-induced events, such as sea level rise or storm surge or cyclones, then that would be a physical risk facing the business. Or the transition risks. This is the risk that are associated with a transition to either a lower carbon or a carbon neutral economy in the jurisdiction in which the business conducts its activities. And there are legal components there, but there's also policy components. It's about predicting what might be the new regulatory regime that will govern business in the future. So just dealing with the physical risks, I've just popped up some particular news headlines talking about how climate change is posing these risks, physical risks to business. So we can see it from the floods, we can see it from the bushfires, we can see it impacting upon the insurance and finance companies. Transition risk, this is, as I say, the risk associated with the transition and to lower carbon economy or a carbon neutral economy. And we've heard discussions about jurisdictions leading up to the COP26 in Glasgow, whether they should embrace the net zero emissions by 2050. Australia hasn't yet committed to that, but it may come before the COP26. But there will be a risk associated with that, and especially if there is a rapid transition, because it's not just you've got to wait to 2050 and do it, you've got to phase that in to be at that position by 2050. And we can see that that has impacts on various businesses. So you can see from the headlines there that there will be a risk to these businesses if they fail to make that transition. And then I come back to the liability risk. And so there could be liability in a number of ways, and I'm going to refer to some of the court cases which expose the businesses to liability. But what we can see there is a former High Court judge, the Honourable Kenneth Hayne, saying this: a director acting in the best interest of the company must take account of, and the board must report publicly on, climate-related risks and issues relevant to the entity. And failure to do so may lead to liability, not only for the director, but also for the company. And again, we can see some reports there which talk about these liability risks. So let's just take some examples where we're starting to see the actions that former Justice Hayne talked about. So three carbon majors, Exxon, Chevron, and I'll come to Shell in the next slide. So Exxon. So there has been litigation in both Massachusetts and in New York, but here was an example, the New York one I've focused on, where it was alleged that there was a fraudulent scheme by Exxon to deceive investors about the company's management of risks posed by climate change regulation. Now, I'm not interested at the moment as to how those matters are being resolved by the courts. They will, of course, be resolved according to law. What I'm interested in just exposing in my remarks is that this is a potential liability risk. Chevron. So in March 2021, some various NGOs filed complaints alleging that Chevron misled consumers about its commitment to reducing fossil fuel production. And then we've got one where Shell, in the District Court of The Hague, it found that Shell had violated its duty of care under the Dutch law, and it had an obligation to reduce greenhouse gas emissions in line with the Paris Agreement targets. Now that is a mirror of the agenda litigation. The agenda litigation was, of course, against the Dutch government, but here with again a Dutch company, Shell. And so that there is an obligation, different sources of legal liability, but we can see that type of litigation. And we can see that that decision was picked up by commentators, and the question in their blog was what the Shell judgment means for US directors. And so it was suggested that boards will need to think expansively about potential tortious liability risks relating to climate change and to ensure they have systems in place to avoid being sued and potentially found liable by a court. So this includes considering whether and how to adopt and implement Paris-aligned business strategies. By Paris-aligned, of course, they're referring to the Paris Agreement, and that are consistent with emissions trajectories that limit global average warming to 1.5 degrees. If the directors don't take the steps today, then they may breach their duty of oversight or duty of care, skill, and diligence. Now, I've spoken there about the physical risks, the transition risks, and the liability risks. There are three types of climate-related risks to business. But there is another risk, and that is the reputational risk. And this can be described in terms of a social license. So we all know what a legal license is. It would be a license under some particular legislation where there is a need for an approval to carry out a particular activity or business. But merely having that legal license may be insufficient. There also may need to be a social license. So what is that social license? Well, it refers to the latitude or freedom that society or a community or a group allows a business to use land and its resources without interference by society or to conduct a business. And so if they don't have that social license, then the businesses may be exposed to significant business risks by society or a community or a group seeking to protest against and interfere with the business and its activities. And we've seen that in various examples. So a year or so ago, there was the destruction of Duncan Gorge in Western Australia. Now that was an area which had Aboriginal cultural heritage of great significance. Now, Rio Tinto had a legal license. They were allowed by their mining license to carry out the open iron ore mine, and that involved dynamiting the geological strata, which included the caves. So they committed no breach of the law by doing what they did. Yet there was a huge uproar and has led to an inquiry, which is still ongoing and reporting, and it led to an overhaul of the board and senior management of Rio Tinto. Why? Because of this absence of a social license to do what they did, and that led to a reputational risk. I've put up another headline. So CBUS, one of the superannuation funds, decided that it should sell its shares in a coal mining company, Chinois, which has a proposal to open a coal mine in Gunnedah. But again, the facts there suggest that there are Aboriginal cultural artefacts and places in the site that is going to be mined. And so there may be there's a legal license to go and mine, but there may not be a social license, and that had a consequence that an investor decided to divest. Here's another example. So the Commonwealth Superannuation Corporation, it decided to divest from certain coal mining companies, that is, ones which only invest or their whole business is coal mining. There are some businesses, of course, that have as part of their portfolio of activities coal mining, but they do other things. The divestment that the Commonwealth Superannuation Corporation was concerned with was so-called pure coal miners. But we can again see that that is done, has a reputational risk to the business associated with that. So that's what I want to say about the first, as to why it is that there should be the provision of holistic advice, which includes the law, but also includes other aspects. So my second topic is now concerned with the law. And my central point is that when we provide advice about the law, it sounds clear-cut that, well, don't we just provide, we know what the law is, we're going to provide advice about the law. But the problem is actually finding out what is the law is extremely difficult. And I say that because of 4 reasons, and I'll unpack each of those. The first is that when we come to find the law, we have to interpret the law, and then we have to apply the law that we've found and interpreted to the particular dispute or legal problem at hand. And there are choices involved there, and so that it makes it quite ambiguous and uncertain as to quite what is the law to solve a particular legal problem. The second problem is that as fast as we think we know what the law is, it changes. And there's this rapid evolution of the law, and that's particularly so with climate law, and I'm going to explain that. The third is an interesting one, and that is we're providing advice to clients about what the law will be in the future. So we say that the conduct is today, but if it goes to court, the court won't decide until many years down the track. And we're having to make a prediction as to what the court might decide many years down the track. And that creates uncertainty. And the final one is that the law, the dividing line between law and fact or law and policy is quite ambiguous. And we have to recognize that fluidity between law, policy, and fact. So let's start with the first one about the uncertainty of what is the law. Now, I've written elsewhere about this, but there's really a syllogical reasoning process. And that is you have to find the law and you've got to interpret it. That will be your major premise of your syllogism. And then you have to find the facts, and then you have to apply the law to the facts to find out whether there is a breach of the law, and if so, what should be done about it. Now, at every stage of that 3-step process, there are endless choices. So it's not clear-cut what is the particular legal rule that we should be applying. Even if we find what the law is, there'll be doubt about interpreting it. That's particularly so with environmental law, which is statutory, and they use words of indeterminate scope and high level of generality. And then, of course, we have to apply it to the facts, and the facts themselves may be ambiguous and uncertain, and so therefore applying the law to the facts itself brings uncertainty. So all of those stages and the uncertainty associated with stages means that it is difficult to advise unequivocally as to what is and what is not the law, and therefore what will be the legal solution to a particular problem. Let's come to the next point about the rapid evolution of the law. And so Professor Liz Fisher has used this expression, which was used elsewhere, that environmental law is hot law, and that it's ever evolving and ever changing. And that evolution and rapid change in the law makes it difficult to ascertain what is the law at any particular time. And with climate law, that is especially so. So not only is climate change, of course, changing rapidly, and its consequences are becoming more acute, as the Code Red for Humanity report showed just recently, but it also means that it has consequences for what will be the legal responsibilities of not only government, but also businesses. So the view that might have been thought that there are very few legal responsibilities of either government or enterprises in relation to climate change, that it's only intersects with particular types of businesses, though that's being challenged by litigation throughout the world. So I'll give you some examples. So first, let's start with government. So again, there had been a view, if we think about it, even up to the Copenhagen COP, so before the Paris, where it still was thought that government really had no legal responsibilities. We hadn't yet seen the cases coming through and being successful, which showed that government had those responsibilities. And it probably wasn't until the 2015 with Agenda that we started to see this change in the legal landscape, where governments were being held responsible. And I want to just pick one of them, and that is the recent decision of the German Constitutional Court, where it said that certain legislation that their parliament had passed were incompatible with fundamental rights, and that they had failed to set sufficient provisions for emissions cuts beyond 2030. So there we can see that the legislature is being held responsible. But what about the executive arm of government? Well, a recent action in Australia by youths, so one of whom was Sharma, against the Minister for the Environment, arguing that the minister owed a duty of care to the plaintiffs, who are youth plaintiffs, under the Environment Protection and Biodiversity Conservation Act in deciding whether to approve an extension to a coal mine in New South Wales. And there's many aspects of the judgments which are worth quoting. I've just picked up this quote, which talks about this rapid evolution and change in the law. So this one is referring to the cases which they were reviewed by the judge, demonstrating the willingness of the common law to respond to changing social conditions, and that leading to a change in the common law to impose responsibility on the minister under the EPBC Act. Now, that decision has been appealed by the minister. Again, the result is not so important. What I really wanted to show here is how quickly what we think is the law and what are the legal responsibilities can change. So let's change to the corporations. Now, I've earlier referred to climate-related risks, that is the physical, the transition, and the liability risks. But I want to also talk about the responsibilities in relation to disclosure. So it's one thing to manage the climate-related risks, it's another thing to disclose it. And what we're seeing is a rapid change in the legal responsibilities of corporations in relation to disclosure. So back in 2016, the G20 Financial Stability Board established the Task Force on Climate-Related Financial Disclosures. And that released a report with a set of recommendations for voluntary disclosure of climate-related financial risks. Now, what we see is that's then been picked up by two bodies regulating corporations in Australia, ASIC and the Stock Exchange. So ASIC, and I'm not going to quote it, but we can see here that they're picking up that the law does require review to include a discussion of climate risk when it's a material risk that could affect the company's financial performance. APRA, the Australian Prudential Regulation Authority, has released its guide on what APRA-regulated entities need to do in managing and disclosing climate-related risks and opportunities. The Stock Exchange Governance Council has a recommendation, again, saying that companies should report on these risks, and that includes risk associated with climate change. In New Zealand, it's been taken further. It's been put into legislation. So a recent bill, the Financial Sector, Climate-Related Disclosures and Other Matters Amendment Bill 2021, would require the next, once it's enacted, the banks, asset managers, insurance companies of a certain size to disclose their climate risks in relation to that task force report that I've earlier referred to. And we can see that the shareholders are starting to exert pressure on companies to disclose their climate-related risks. They're doing so through moving resolutions at AGMs and investor meetings requiring such disclosure. And there's been various reports looking at how effective the disclosure has been by major companies. So an Australian body, Market Forces, looked at 72 ASX listed companies and seeing what their public disclosure of climate risk was. And Client Earth did a similar analysis in the UK and found them to be falling short. So we can see that there is a risk associated with this. But beyond this sort of disclosure, it's now being recognised that it's not enough to simply sort of manage and disclose the climate risks, but positive steps need to be taken. And this is a recent report by Noel Hutley and Sebastian Hartford-Davis. They've been given 3 reports. This is the latest one, but where they're picking up and saying they've got to identify and manage risks, design, implement strategies, select and use appropriate standards, to make accurate assessments and disclosures, and deliver on the company's commitments and targets. So my third area as to why it's difficult to find what the law is this phenomenon that I've said, is that even though there is action today, that is, the corporations make a decision today or about what they will do, they'll be judged tomorrow as to whether that conduct today did or did not comply with the law. And so that makes it difficult for lawyers to provide advice as to what will be the position in the future. And my final way in this section is talking about this interaction of law, policy, and fact. And we need to recognise that it's not simply a matter about the law alone. The facts and the policy do particularly apply. And so cases are regularly raising these issues about the government policy and other policy, Paris Agreement perhaps, and how that may intersect with the legal problem. And I've given my own decision there as a reference of that intersection and interaction of law, policy, and fact. So now I turn to the 3 topics of ethical duties, and I'll move through a little bit quicker on some of this. So my third topic is a general one. We, as lawyers, are all subject to the legal professional rules, and they govern what we can and can't do. But the important point to do about that, to recognise about those, is they set the base, but they're not exhaustive. So we need to comply, of course, with any of those laws and rules that are imposed on lawyers by regulatory bodies. But we also need to look at the legal profession's special status as a profession. And so that mere compliance with those legal professional rules don't discharge our ethical duties. And so the Chief Justice of New South Wales, Tom Bathurst, said this, that ethical thinking does, and if not, it should, pervade all aspects of legal practice. And he went so far as to say, obedience to a comprehensive code of ethics is the defining characteristic of the profession of a lawyer. And so if we take that for a moment and we think about what it means that the ethical standards of what it is to be part of the legal profession affects how we go about our day-to-day business. And so the climate conscious lawyers will appreciate these ethical dimensions of legal practice. And so ethical thinking about climate change and its consequences should pervade all aspects of legal practice, picking up those words of Chief Justice Bathurst. Let's come to the next ethical one. And this is, there is a duty of lawyers, of course, to the court and to the administration of justice. But it also goes further to support the integrity of the legal system. And so that is that not only to uphold the law and to obey the law, but to ensure the efficient and proper administration of justice. And as we know, these duties to the legal system override any particular client interests that are contrary to the duties. So this picks up the idea of responsible lawyering, and that a lawyer's role is to the court, and the lawyer's role is also a guardian of the legal system. So a responsible lawyer takes the duty to the court and the administration of justice into account personally in decision-making and advising clients and how they act in court. So I've said that there are these grey areas, the choices in the identification, interpretation, and application of the law to a legal problem or dispute. And so lawyers, a responsible lawyer, will choose in these grey areas ways that will contribute to the equity, effectiveness, enforcement of the law, and that upholds these fundamental values and integrity of the legal system. And so that also includes upholding climate change justice. Now, conversely, the responsible lawyer will avoid abusing the legal system. So that is putting up arguments that have little prospects of success, or that will frustrate the substance and spirit of the law, or that will use loopholes or procedural rules or arguments. So the concept of slap suits, where they are used to sort of chill access to justice, that would be an example of an abuse of the legal system. So my last topic then is dealing with a personal ethical approach. And so this is coming down to sort of how we act individually. And this is the more difficult area. But we would like to think that in our day-to-day practice, we would have a congruence between our personal ethical beliefs and what we do as lawyers. That if we have this discordance between what we ethically believe personally and what we do, then we are going to find life difficult. So I want to suggest ways in which we can bring this congruence between our own personal ethical beliefs and what we do in our daily legal practice. And I suggest 6 ways. The first is what has been referred to as client counselling. So this means that in that dialogue of providing that holistic legal advice, we may discuss the rightness and wrongness of a particular project or a particular activity that the client is engaging in. This doesn't mean that we're imposing our moral view on the client. We're just exposing it for them to think about. And it may well be that having done that, the client says, I agree with you. I will change the way I conduct this project, or I won't pursue this particular activity, or I won't. That's entirely a matter for the client to decide. But you're raising it for their consideration. And that's all that client counselling is doing. The second is being active in promoting human rights. I've spoken earlier about how Laurasia and the IBA had suggested that this is incumbent upon lawyers, that they should raise these issues with clients about the impact of a client's business on human rights. And so it will be bring that actively to the client's attention. The third is working with certain industry groups. So clients will be parts of industry groups, and it's working with those industry groups to see whether there can be more sustainable business models. And I give an example of a group of barristers in Chancery Lane who came up with a climate contract playbook, which includes climate-friendly contractual clauses that they could use in their contracts. So why not include some of these in the contracts that the business is engaged in? There can also be active encouragement of law reform. And so that is by all branches. So with the executive, policies that could be done to be more climate friendly and to address the climate crisis. That's one of the recommendations in the IBA climate crisis statement. Or working with the legislative branch of government to say what should be effective climate laws, legislation that should be passed. Or could be working with the judicial branches by way of assisting in education. My fifth one really comes back to the academia. and saying that particularly legal scholars and practitioners who are involved in sort of academic pursuits can engage in this intellectual activism to build climate consciousness and how it can reform the law, the legal systems, the legal profession to better address the climate crisis. And the last is providing pro bono services, and that's been a feature in Australia that lawyers have been prepared to engage pro bono to assist clients in actions in the courts. But it could be also in other activities and not just activities before the court. So there can be seen to be sort of a way of encouraging both the law firms, and I'll come to the lawyers. So this was an initiative of law students in the United States who ranked 100 law firms to see what were their climate impact under 3 topics: lobbying, transactional work, and litigation. And they found some interesting perspectives. And so there was making awareness, publicity about what was the ranking of the law firms, but that may in turn change the law firms' behaviour because they may not like their ranking, so they may change in the future. And I'll give a call out here to the Victorian Environmental Law Student Network, who have been active in considering this concept of climate conscious lawyering, and they're preparing a code for climate and environmentally conscious lawyering. So picking up what's in a different way, what the US law students did. And we need to think about ways in which we can have legal education. And so that means not only at the law school, so we need to change the focus of legal education, but I think increasing the salience of climate change issues in all the compulsory law courses. So it shouldn't only be taught as an elective course in climate law. It should be woven into the fabric of the compulsory law courses about climate consciousness and the issues. But it also, of course, involves continuing legal education, continuing professional development of lawyers, and that's been picked up, of course, by the IBA. Here I'll come back to Professor Margaret Young, her article I earlier referred to, where she's talking about that these 3 areas of focus for legal education. So substance theory and critical engagement. So substance, to try and increase the knowledge and proficiency across all areas of law, and not just about climate change law itself, and understanding how they all fit together. Theory, so revisiting the theoretical foundations of our legal rules, the legal institutions and orders, and having a critical engagement, so having a critical perspective and encouraging this ethical evaluation of our laws. And I'm talking about continuing legal education, and that was one of the recommendations of the IBA climate crisis statement, that there be this continuing legal education. So they're my 5 ways. Hopefully I've explored why it is necessary to have a climate conscious approach and how we can do that in those areas in daily legal practice. And so that concludes what I'd like to say. Thank you very much for your attention.
Thank you, Chief Judge. And we now have some time for Q&A. And Chief Judge, the questions have been coming in thick and fast on the Q&A as you've been speaking and still appearing. So we'll try to get through as many as we can. I think just picking up on some of your last points about the role of legal education in building climate conscious lawyering and lawyers. There are some questions in the chat about how we move out of our disciplinary silos and in fact prepare for a future where we can be climate conscious lawyers. So what sort of training or knowledge or experience do you think we should be providing in an educational setting? Should it be something like more interdisciplinary courses, for example?
I think it means challenging the taxonomy that law schools engage in the way they teach. So where we, if you think about a traditional taxonomy where we've got a sort of like a decision-making tree where we sort of have law at the top. We then divide it into perhaps civil law and criminal law. We might divide it into common law and, statutory law. We might then sort of, further divide it into, tort or contract or administrative law. And we keep doing this drop down categories. And then we then teach those individually. So that's been a very traditional way of teaching it. And so that encouraging this silo mentality. And of course, it's quite unrealistic. I said earlier that a client doesn't walk in and said, I think I've got a restitutionary claim here. Or look, I was thinking that this might be sort of the tort of, misleading sort of representation or conspiracy. They just don't walk in with that. They come in and say, this person has done this wrong to me. And, you then are trying to work it out. So in fact, what we've been doing in legal education is the wrong way for a very long time, that we've been siloing these different areas. And so then people only work in that area, and legal academics are becoming more and more specialized. And so that, people say, I only teach international law. I don't touch anything else. I only deal with torts and I won't touch anything else. But we see it in the law firms. In the law firms, the generalist lawyer is now frowned upon. You've got to be a specialist. You've got to be in your sort of particular practice group, and then you've got to become more and more specialized in this particular area. Now, all of that is working against this holistic way of solving problems. So my climate conscious lawyering approach is really sort of working at an existing problem and saying that we need to break over that. Professor Doug Fisher suggested that ecologically sustainable development, so one of the areas of environmental law, should be seen as a form of a Grundnorm, something that Han Kelsen talked about. But in a sense, what we really need to do is to get back to some of those overarching norms and think about what they are and how they then infect and influence all the other areas of law. When we start taking that approach, then I think we will come up with this holistic way of looking at the problem. So it's a more complex problem than just only about climate change and climate conscious lawyering. It's a broader problem that we need to change the way in which we think about the law.
Thanks very much, Chief Judge. And another question that's been raised in the chat really responds to your points around uncertainty and interpretation of the law, asking how you actually assess the capacity of our appeal court judges in a general sense to extend the common law to embrace climate accountability, for example, for corporations. And also I note that Robert Southey, one of the family members of the sponsoring the lecture here today, has also asked if you would like to share any opinions about the current Sharma appeal that's going before the federal court.
Look, obviously there is an advantage in having some degree of literacy in environmental law and climate law. That assists. That's why specialist environmental courts, such as the court I'm the Chief Judge of, the Land Environment Court, does have an advantage because this is what we do all the time. So practice makes perfect. If you do it all the time, you tend to get to know it. And that's appellate courts are generalist courts, and they haven't got that. But as a general rule, the appellate courts, their members are excellent judges, and so they're excellent lawyers, and so they have the tools to be able to apply to any legal problem. So I don't think that there should be a problem when they come to deal with it. It's a matter of obviously the strength of the arguments that are put before them. But if there's a good argument, then I think that it will be recognised by appellate courts just as much as it will be from courts at first instance. And we're seeing that some of those cases that I referred to, the German Constitutional Court, it's a constitutional court. It's not concerned with climate change or environmental matters. Or the Supreme Court of the Netherlands, when it made its decision in Urgenda. Or, there's been other apex courts around the world. They're generalist courts and they've made decisions. So I think we can still get very good quality decisions from these generalist courts. So I don't think that's a problem. And in respect to the Sharma case, I think I'll just answer it. So thanks for your question, but no thanks.
Yes, probably a wise judicial response there. So I might just ask one final question, and I apologise to our participants that we can't ask them all. But a question about, with these other cases that you've discussed, Chief Judge, the cases in Germany, in the US, etc., to what extent are those kind of cases transferable to our Australian context? Can we see a sort of similar line of jurisprudence potentially arising here?
They're not directly transferable. They have to be adapted. So let's just take the first instance decision in Urgenda. So that was under the Dutch Civil Code, the duty of sort of hazardous negligence, or I put it in shorthand. The duty of care under the Dutch Civil Code overlaps but has distinguishing characteristics or elements from the duty of care in Australia. So you couldn't take it directly across. That's not to say that you can't be inspired by the decision and start to think about, well, could we adapt the reasoning to fit the particular characteristics and elements of our law? So that's it's more as an idea source, an inspiration, than direct transferability. Or let's take the, again, staying with the agenda decision, but this time with the Hague Court of Appeal and the Supreme Court of the Netherlands. So they upheld it on the basis of the European Convention on Human Rights. Well, again, we don't have such a convention, and we don't, human rights is difficult to uphold in Australia. It may be in the fabric of the common law, but there is particular laws in Queensland, ACT and Victoria. The creativity is required to see, well, how could we take an argument that's been used there and apply it here? And so in the Land Court in Queensland, there was a interlocutory decision, for true, but there was a challenge as to whether the Land Court, in making a decision about whether a coal mine should be approved or not, could take into account the Queensland human rights legislation. And there was a decision to say, well, it's not legally irrelevant, it's not precluded, so it could be taken into account. Now, how it will be, we don't yet know, but it was the decision at the moment was, well, it could be relevant, and it was allowed to remain as an issue. So there you can see they're starting to play with how do we transfer the idea and start to apply it to its local context. And that, what I think, is the exciting aspect of particularly environmental law and climate law at the moment. There's this globalization that's occurring, and so again this sort of silo mentality that we had, the common law jurisdictions, and they were quite different to civil law jurisdictions based upon the Napoleonic code, or based upon the Dutch Roman Dutch law, and that we could never talk to one another. I think what's happening in environmental law is that they are getting this transferability of ideas and reasoning between different courts, and that's what I think will be seen. And so that's the degree of judicial dialogue that I see happening.
Thanks, Chief Judge. I think we'll have to draw it to a close there, though. There's many more questions that I'm sure people would like to put to you, but it's my job now to offer a vote of thanks to you, but first also to thank the Southey family for the generous ongoing support that they have for this important lecture. And I think what we've seen tonight is how this support for this memorial lecture allows the law school to engage with some of the more foremost legal thinkers in their fields and provides a platform for discussion of legal contributions to key global challenges, and undoubtedly climate change is one of those. But I liked your message, Judge, that you ended up on there of hope and creativity. And I want to extend to you our very great thanks also for, at a time that is one of difficulty for many during lockdown and COVID restrictions, still agreeing to engage us on this topic. I think the message of your lecture tonight on climate conscious lawyering is really a call to action in many ways for students, for scholars, for the profession more generally. And the wider community to think about how we best put our knowledge and our skills and our talent towards the imminent and urgent challenge of addressing climate change. And that's only emphasised by the Intergovernmental Report, Working Group 1 report, the Code Red for Humanity that you started the lecture by referring to. So to our audience, thank you also for attending the lecture via the webinar tonight, and I hope that you've also been inspired by the Chief Judge's words, the call to action, and indeed the possibilities of an exciting new way of understanding our duties and our actions as lawyers in a climate conscious way. So our sincere thanks, Chief Judge, for sharing your thoughts with us on this topic tonight for the Alan Hope Southey Memorial Lecture at Melbourne Law School. So thank you very much.